Hi there, we're continuing our review of the Delphi appeal. I'm glad to have you here. We have gone through the defense's assertions of all the reasons that they believe that Richard Allen is entitled to an appeal. And right now I don't know if this video is going to finish it up, but we are going through the state's response as to why that should not happen. But the court did grant a hearing, which I believe is September 21st, 2026, so that they can hash it out in oral arguments. But we're going to continue on with what the state says the defense got wrong on the appeal issues, okay? And here we are with the state saying, look, the court properly admitted Allen's confessions. They say, although Allen did not preserve this issue, the trial court properly admitted confessions Allen made to his family, Dr. Walla, and correctional staff. Okay, now what preserving the issue means, I'm not an attorney. I'm just a law enforcement expert who loves the court pleadings, been involved with the court since my very first job. Pretty much was, besides a grocery checker, was a paralegal, okay? My very first professional job. And I love the legal back and forth, okay? So what they're saying here is that Allen did not preserve the issue. And in order for things to be considered at appeal, right? Obviously you want to consult a lawyer. But in order for things to be heard on appeal, we've heard that, right? Heard on appeal, they have to be what's called preserved. They have to be brought up in some method so that they're on what's called on the record, right? You can't just, unless typically we see it's new evidence that was not available, something that was not available at the time, so it could not have been brought up. But other than that, you have to bring it up. Okay, so that's what they're saying here. They're saying the confessions, this is the state, remember this is the state, the confessions were voluntary, not the product of state coercion, and therefore did not violate Richard Allen's due process right against self-incrimination under the 5th and 14th Amendments or Article 1, Section 14 of the Indiana Constitution. And what's important about that is the state appears to be making the argument that because Richard Allen was jailed in a prison and subject to solitary confinement prior to his trial, it was, bad business about what that solitary confinement did to him. And he had a psychotic break, which therefore this treatment, this custody made the confessions. Right? We've been through all that, but that's where we are, okay? The state says his other constitutional claims are meritless, and the trial court properly excluded the I-pass settlement, which I'm still not exactly sure what that is. Sounds like they went through something else. They argued something else, litigated something else, and had a settlement. Not sure. But this was not relevant to the voluntariness inquiry, right? You cannot be in custody and be forced to testify against yourself. We've seen, people just in court take the 5th, right? They make incriminating statements by coercion or means otherwise, right? It has to be voluntary. So the state says the issue is unpreserved. Although Allen renewed his pretrial objections to the confessions before the correctional officers and Dr. Walla testified, he did not request a continuing objection or contemporaneously objected testimony about the confessions. So it sounds like the state's saying, look, it had to be a continuing objection, or he had to contemporaneously, meaning at the same time, object to testimony. Okay, so when the testimony came into the court, potentially during the trial, they had to raise their hand and say objection, right? We see that all the time. Okay. More importantly, he affirmatively stated he had, quote, no objection, end quote, to the documents memorializing his confessions to correctional staff and Dr. Walla, and he objected only to a different basis, only on a different basis to recordings of his confessions to family. Now, interesting, again, because I don't know these cases before I come into these and read these, so I'm not sure. I'm wondering if his appeal attorneys are different than his trial attorneys. Okay, that I don't remember seeing anything about ineffectiveness of counsel, but sometimes that's used, that things that should have been done before trial and at trial were not done, okay? Because this is the state bringing these things up according to the rules. These things should have been done this way. To make this objection or to make this issue, it should have been done this way. Also, it says here, he said no objection. Like, okay. So what do you do with that? And he does not argue fundamental error, thereby waiving that claim. So the state's saying he doesn't have a leg to stand on in these using these rules. And it said the court should find the issue waived. Allen's confessions were voluntary, and we could read the document that orders the hearing to see if the judge addressed any of that. Allen's confessions were voluntary. Both the federal and the state constitutions prohibit the admission of involuntary confessions. Okay, involuntary being the word there, coerced, whatever you want to call it, okay? A confession is involuntary when a person's free will has been overborne by violence, threats, promises, or other improper influences, okay? And they're citing Indiana's here's a U.S. case, Schneckloth versus Bustamante, Wilkes versus State is Indiana, it looks like. Voluntariness is assessed under the totality of the circumstances. Where have we heard that before? Probable cause, right? Under the federal constitution, the state must prove voluntariness by a preponderance of the evidence. And the ultimate determination of voluntariness is reviewed de novo, which I don't know what that, we keep seeing that word. Though underlying factual determinations are reviewed only for clear error. Under the state constitution, which is Indiana, voluntariness must be proven beyond a reasonable doubt. But the trial court's determination of voluntariness is, quote, reviewed as other sufficiency matters, end quote. An appellate court will not reweigh the evidence of voluntariness and views the evidence in the light most favorable to the trial court's ruling. So that's interesting. So it kind of sounds like, again, I'm not a lawyer, so I don't understand all the legalese, but the language kind of sounds like, although voluntariness must be proven beyond a reasonable doubt, the trial court only has to review it, like the word sufficiency is there, right? And that sounds like two different things. Sufficient, it's sufficient, and it's beyond a reasonable doubt. So it sounds like maybe the defense has to argue that it's not beyond a reasonable doubt and that it's only sufficient or less than sufficient. I don't know. That wording is interesting to me there. And what the state says here is an appellate court will not reweigh the evidence of voluntariness. So it sounds like what they're saying is the state's not going to get into, was it beyond a reasonable doubt or was it sufficiency? Okay, was it there or not? Like not how much of it was there, right? So, sounds like a big hurdle, right? Okay. If there is a substantial probative evidence, If there is a substantial probative evidence supporting the court's conclusion that the statement was voluntary, the conclusion will not be set aside. So it's either voluntary or it's not. Not how big of voluntary it was. Okay, was it a big gift or a little gift? No, it's a big surprise or a little surprise. No, it was a surprise. Okay. Coercive state action is a prerequisite to involuntariness under both constitutions. Okay, so now they're saying that the statement has to be voluntary and it can't be from all those things that they listed. The defense is arguing coercion. So the state now is saying, okay, here's the parameters that it can be judged voluntary or involuntary. And the state, it either is or isn't. And the trial court determines it is or isn't. All right. So they're like, well, the trial court determined it was. So now, was it coercive? So coercive state action is a, quote, necessary predicate, end quote, to a finding of involuntariness under the federal Constitution. All right, a necessary predicate. A predicate is a precursor, a founding part of, it's like a stepping stone, a predicate to get there. Like you gotta step on coercive action to get to involuntariness, if we can say that. The Constitution, and this is Connolly, the Constitution, quote, is not concerned, quote, with moral and psychological pressures to confess emanating from sources other than official coercion, end quote. And that's an interesting statement. What other coercion sources would be other than official coercion? Right? I find that interesting statement. Oh, here we go. They're going to tell us under Elstad and U.S. v. Garrow, parentheses, stating that due process does not protect a defendant, quote, from his own compulsions or internally applied pressures which are not the product of police action, end quote. So if you freak out, yourself and can't control yourself, I guess, and you confess, that's on you. That's on you, right? So if the police, let's just look at a regular situation. If the police read you Miranda and you decide to talk to them, and there's no coercion, that's on you, not on them. If there's no coercion, right? It's just you made the decision. Okay. And they're using the word compulsion or internally applied pressures. I don't know what that is, but interesting. Okay. It says, this remains true even when a defendant suffers from mental illness. Quote, a defendant's mental state is not enough to render a confession involuntary in the absence of coercive police activity, end quote. Smith versus State. So if your mind is not right, that's not the state's problem. And they are saying U.S. v. Newman here, parentheses, evidence of a defendant's mental condition that, quote, impaired his cognitive or volitional capacity is never by itself sufficient, end quote, to render a confession involuntary for the purpose of due process. Okay? So volitional capacity is will. Even an actively psychotic or delusional defendant can give a voluntary confession. So let's walk through this. The defense is saying that they put him in the prison awaiting his trial, and usually pretrial detention is different. You're in a jail, you're not in a prison. And pretrial is different. It's usually at a lesser level. Okay. We don't know what facilities they had or whatever, what the decision was. But, so the defense is saying they put him in this prison. They knew he had multiple, MDD, the major depressive disorder. They put him in this solitary confinement over the 30 days, if you remember, and he became psychotic. Okay. Now, the state is saying here through these court cases that the court has determined, well, even if you are psychotic, you can give a voluntary confession. They say a defendant's mental condition is relevant to the voluntariness inquiry only insofar as it renders the defendant more susceptible to police coercion. That's interesting. Let's see what that says. The defendant's mental is relevant to the voluntary more susceptible. So they're saying a mental illness, I think I'm right, let me know. A mental illness might make you more susceptible to coercion than being voluntary on your own. It's kind of what it sounds like. Although Allen asserts coercive state action is not a prerequisite under the Indiana Constitution, he provides no analysis to support this assertion, and the Indiana Supreme Court has never held this. Okay, so it sounds like the defense is saying, this is the state saying, the defense says state action isn't required in Indiana to be coercion. And there's no analysis for that. And the state says baloney. The Indiana Supreme Court has never said this. So I don't know where you're getting this. You have given me no basis for this. But whatever, the Indiana Supreme Court never said this. They state that the case cited by them, Robbins v. State, contains only a generic reference to the state constitution, no separate constitutional analysis, right? So there's no case that was litigated, right, when we see this, the Supreme Court's opinions, the higher court's opinions, and no suggestion that the definition of a voluntary statement under the state constitution differs from that under the federal constitution, right? So when you see in these appeal court decisions, they discuss it and they use words and things, and those citations and those wordings show the intent, their thought process, and then that moves forward. So the state here is saying there's nothing. There's nothing here. They say that in Schneckloth, defining a voluntary statement is essentially the same terms as Robbins. Okay, this is this case here, this Indiana case. And no other justice has ever adopted Justice DeBruler's concurring opinion in Linthicum v. State, suggesting that police coercion might not be required under the Indiana Constitution. So maybe DeBruler raised it and nobody concurred or whatever. Neither Robbins nor Justice DeBruler identified the applicable constitutional provision, Section 14, or engaged in any analysis, and both cases involve statements made in response to police interrogation, not volunteered statements. So they're saying, what are they basing, if they're using those justices' statements, what are they basing it on? And it was on interrogation, not volunteered statements. Further, the state says state constitutional questions are resolved by examining the language of the text, parentheses, the quote, first line of inquiry, end quote, the history of its drafting and ratification, case law interpreting it, and the purpose and structure of our Constitution. All right, it's talking about what the Constitution is saying. As explained in Section B below, under the Indiana Constitution, the prohibition on the use of involuntary statements in criminal cases rests solely in Article 1, Section 14's protection against self-incrimination. And Section 14 protects only against, quote, compelled, end quote, testimony. It is not a right, quote, not to be forced to speak, end quote. Those are interesting words. What's the difference? I mean, I'm just asking this. What's the difference between compelled, as a word, it's highlighted here, and not to be forced to speak? What's the difference there? What's the difference there? And the compulsion, the state says, it protects against a state compulsion. Interesting. It talks about Aldridge here. Protects against compulsion by legal process. Allen identifies nothing in history, text, or precedent that suggests Section 14 protects against a compulsion to confess that is independent of any state action or that it applies to volunteered statements not made in the presence to police interrogation or state-compelled questioning. Without coercive state action, there can be no compelled testimony under Section 14. Now, are they saying a compulsion is like an urge, right? It's not a, what word did they use? It's not a force. It's not a beating it out of you. It's a compulsion. It's a internal urge, maybe. And they've identified nothing that just because you were compelled, and the Section 14 only talks to state interrogation or state compelled questioning, not voluntary. So I guess maybe the state's saying, okay, well, if you felt the prison, the whole picture of that was force, it wasn't like it was his own internal compulsion, I guess. Interesting visuals here, right, as we analyze the situation. They're saying too, coercive state action is absent in this case. None of the usual hallmarks of police coercion are present in this case. What are the usual hallmarks? I'm just asking. Allen's confessions were entirely volunteered statements. They were not made in response to any law enforcement interrogation. They said Allen was not subjected to torture, beatings, or physical abuse by law enforcement. So I guess the phone book thing is a hallmark. What word did they use? Hallmark of police coercion. Beating it out of you or something like that, right? He was not threatened with harm or offered any promises in exchange for his confessions. But if I remember correctly, weren't they saying that they said something about his behavior changing a little bit? Did he feel, I'm just asking the question, could he have felt that he had to say something to get out of solitary? I don't know. I don't know, right? We hear when we watch the shows on false confessions that the person felt that they had to do whatever they had to do to make it stop, to get out of the room, to get sleep, to get food, to get whatever, right? Correct me if I'm wrong. So is the defense saying, and the state is interpreting, or is the state just positing that that's what the defense is saying? And down here we have a footnote. Even if coercive state action is not a necessary prerequisite, it is indisputably an important factor under the Indiana Constitution. So it sounds like they're saying they didn't say anything about it, and no justice has ever said anything about it. But just in case, we're going to throw this in, right? Right? It's not a necessary prerequisite, okay? It's an important factor. Okay. Based on the same facts discussed below, the totality of the circumstances shows Allen's will was not overborne. Okay, so what do we have here? Okay. The alleged coercive state action in this case rests solely on the conditions of Allen's confinement in the restricted housing unit. Now, this is what the defense has said. But the conditions of Allen's confinement did not rise to the level of coercive state action to rendering his confessions involuntary. while the, quote, conditions of an individual's confinement prior to confession may bear on the question of whether government conduct was coercive, end quote, the, quote, mere fact that a defendant was held in disciplinary segregation or solitary confinement prior to making a statement, end quote, is not sufficient to constitute the requisite coercion. That's U.S. v. Rivera. So in that case, they're quoting here from the case discussion, the citation and the opinions. So they're saying here, while confinement prior to confession may bear, just because the defendant was held in disciplinary segregation or solitary confinement prior to making a statement is not sufficient to constitute the requisite coercion. Now, they kept him past the 30 days, right? So is it, well, just because we don't have this, it's not right. But what about this plus this plus this? We don't know. Let's see here. There's a case, U.S. v. Giles, in parentheses, confession made after spending 2 years in solitary confinement was voluntary. Okay, so in that case, they said 2 years voluntary. U.S. v. Kendra, parentheses, confession made after 30 days in solitary confinement was voluntary, parentheses. Did they have psychosis? I don't know. Conditions of confinement rise to the level of psychological coercion or compulsion. There's that word that we needed before. Rendering statements involuntary only when they are so severe to be, quote, intolerable, end quote. Okay, what's intolerable? What's intolerable? Circumstances that constitute, quote, outrageous conduct by the authorities, end quote. And they cite this case here, State versus McKay, my home state, parentheses, holding that the conditions of state prison, quote, isolation cells, end quote, were not so, quote, intolerable, end quote, as to constitute coercion, end parentheses. So they keep going. They're quoting these things here. Here's 2 weeks, naked in a small cell with no window, no bed. The court deemed a, quote, shocking display of barbarism, end quote. Donnell v. Myers, confession involuntary when defendant held incommunicado for 11 days in cold, unlighted, windowless cell, where he was kept chained to a wall, fed bread and water, not allowed to bathe, and told he would remain there unless he confessed. I mean, in parentheses. So it sounds like they've looked at, the courts, different courts have looked at varying degrees of confinement, we'll say. And so they're going to ask the court to look at this confinement. Here they say Allen's reliance on Littlefield versus DeLand is misplaced, right? So the lawyers, they try to find precedent in cases to illustrate their rationale or their thinking, okay? So, and especially if it's been proven in a prior case. So they're saying here, in that case, the mentally ill pretrial detainee in that case was held for 2 months in a, quote, strip cell, end quote, with, quote, no windows, no interior lights, no bunk, no floor covering, and no toilet except for a hole in the concrete floor, end quote. Was deprived of all clothes and given no bedding, was denied articles of personal hygiene, was given no opportunity for recreation outside his cell during the entire 2 months, and was not permitted to have any reading materials in his cell. And remember, we heard about all the stuff. He denied the TV. He got out. He got 3 showers a week. Okay. Although those conditions are several orders of magnitude worse than Allen's conditions. Several orders of magnitude worse. Okay. So I would be like, what orders? Like, what are the orders of magnitude of worseness? Right? It's just my thinking. The 10th court, quote, did not hold, end quote, that these conditions for a pretrial detainee were, quote, per se unconstitutional, end quote. Rather, it held that only that they could not be imposed without procedural due process. So I'm not sure if the thing they're talking about in the 10th Circuit is in Allen's case. Oh, they're talking about Littlefield versus Deland, because that's in the 10th Circuit. So they're saying that it was without due process, was what the court held. On appeal, Allen has not challenged the safekeeping order or the denials of his motion to vacate it or otherwise raise any claim of procedural due process denial with respect to his placement in the restricted housing unit. So they're saying he didn't challenge it the right way for that case, the situation in that case, to apply. Allen's confinement conditions were not outrageous or barbaric. Although small, his cell was the same size as the other restricted housing cells and was furnished with a mattress in a bed frame, a toilet, and a sink. It had a window to the outside. When Allen complained the window was scratched, the DOC replaced it. He could dim the light in his cell, and he never claimed that the temperature in his cell was oppressively hot or cold. It is undisputed that Allen was offered regular, nutritionally sufficient food and drink and was given all prescribed medication. He also had access to commissary. He was provided with laundry service and clean sets of clothes every week. Even when on constant suicide watch, he was provided with a suicide smock to wear. He could shower 3 times per week. Except when precluded by suicide watch status, he received 1 hour of recreation 5 days a week in indoor and outdoor exercise areas. He was allowed to have a Bible, other books and reading material, and crossword puzzles in his cell. And he was offered a television for his cell, but declined the offer. So here we have a footnote. Although Allen sometimes refused meals, he never refused more than 4 in a row because he knew that would classify him as a hunger striker. I don't know if they're trying to say that 4-day thing gave him or showed he had some type of mental capacity. I don't know. Allen was never held incommunicado. He was appointed legal counsel and received both in-person visits and private phone conversations with his attorneys. He received at least 2 in-person visits with his wife, a privilege afforded no other inmate in restricted housing. He could receive weekly visits from a chaplain upon request. Allen had a tablet in his cell that he could use to make phone calls to family and others. When he broke his first tablet, he was given a second one free of charge. Also, a privilege afforded no other inmate. Allen could listen to music, watch movies, play games, and send written messages on the tablet. What do you think? Allen also received regular medical and mental health care. He was checked regularly by medical staff, including daily checks while on suicide watch. He also received daily checks by Dr. Walla or other mental health professionals while on constant suicide watch and weekly checks otherwise. And he was offered at least 1 out-of-cell session with Dr. Walla every week. Thus, all of Allen's basic needs were met. He was given food, clothing, shelter from the elements, access to sunlight, basic hygiene, medical care, mental health care, opportunity for exercise, opportunity for intellectual stimulation, opportunity for spiritual care, contact with loved ones, and contact with his attorneys. Okay, and here we have a footnote here. Although Allen was shackled and handcuffed while taking to and from meetings with his attorneys, his wife, and Dr. Walla, those restraints were removed during the meetings. These conditions were not so barbaric as to overcome a person's will. Moreover, except for the several ways in which he received more favorable treatment and the video-only camera in his cell, not sure what that is, Allen's confinement conditions were identical to any inmate in restricted housing. Under the logic of Allen's argument, then, no statements made by inmates in restricted housing, such as their jail phone calls or Mirandized interviews, could ever be admissible. But he cites no authority, and the state is aware of none, that supports such a novel proposition. That is because the conditions of restricted housing, while undesirable, are a far cry from what is necessary to create an involuntary confession. So they're saying Allen's confessions were not caused by the allegedly coercive conduct. For a confession to be involuntary, this coercive state action must be, quote, causally related to the confession, end quote. Allen's argument assumes that the conditions of his confinement caused his brief period of psychosis and that his psychosis caused his confessions. But both premises are belied by the record. Moreover, the state did not attempt to deliberately exploit Allen's confinement or mental illness to procure a confession. Parentheses, explaining that a defendant's mental condition is relevant to involuntariness only when the police seek to, quote, exploit this weakness, end quote, through quote, coercive tactics, end quote, end parentheses. So they're saying the confinement conditions did not cause Allen's confessions. The conditions did not become more oppressive before the confessions began, nor did they become more benign when Allen stopped confessing. And the state never made any threats or promises regarding these conditions predicated on his cooperation or willingness to confess. Remember, I asked the question, did he think that if he confessed, he would get out? He would get out of the solitary. We don't know. Moreover, the confessions were not coextensive with Allen's period of psychosis. So now they're saying they were not only during the psychosis. It says here, he began confessing before he was psychotic. Now remember, the defense talked about the breakdown, the decomposition, that it started all the way, all those months up to a period when they finally gave him the Haldol. So they're saying it caused it, right? So in the defense's mind, it's probably this entire period, the buildup to the psychosis. The state here is saying, look, he began confessing before he was psychotic. Before, remember Dr. Walla, they said that they thought he was malingering and stuff, then they finally gave him the Haldol to start getting his mind right. So, who's right? Who's right? The state is saying, look, he began confessing before he was psychotic. The date he was described psychotic. And he continued confessing after he was no longer psychotic. Well, how long does it take you, I don't know, to get back to baseline? I don't know. Allen was already confessing in early April 2023. But it was not until April 13th that Allen became, quote, gravely disabled, end quote. All right, that's the term. And April 14th that his psychosis and manic behavior became, quote, significant, end quote, and he was involuntarily started on antipsychotic medication. So in the period of 2 weeks, right, because April 13th, so they say he was already confessing early April. Well, what's early April? April 1st? April 5th? 2 weeks, maybe 2 weeks. He became gravely disabled on the 14th and got Haldol on the 14th. How long does it take? Did it start before April? Questions to ask. That's a mental health practitioner needs to talk about that. When does the psychosis begin? By May 2nd and 3rd, Allen no longer exhibited, here's a key word, significant symptoms of psychosis, manic behavior, or lack of impulse control. And he never thereafter presented any significant symptoms of psychosis or mania, but he continued confessing. It depends on how you look at it. Remember our show, State versus Defense. Significant symptoms. I'm just throwing this out there. I'm not on one side or the other, but this is what I love about the legalese, the semantics. If you have a cold, do you get the cold when the bug comes in and before you start the sniffles? I mean, good question, right? When do you get the cold? When does the cold start? Does the cold only start when your nose starts running? Or does the cold start when the bug gets in and it starts brewing in your system? And just because your sniffles stop or you're feeling better, take all your antibiotics or whatever happened, right? Are you done? I love the legalese. With good questions, right? Because it says significant symptoms. It says here, on May 3rd, this is a footnote, on May 3rd, Dr. Walla added a diagnosis of, quote, brief psychotic disorder with marked stressors, end quote, to his record for his presentation, quote, within the last month, end quote. This diagnosis applies when a person exhibited one or more symptoms of psychosis, parentheses, not better explained by another diagnosis, in parentheses, that lasted more than 1 day, but less than 1 month, in reaction to an event that would be markedly stressful to anyone in the circumstances. I don't know. Make of it what you will. I don't know. Alan's most detailed confessions occurred to Dr. Walla on April 5th and May 3rd. So those seem like bookends, right? Before and after his psychosis. So maybe 2 weeks before he got the Haldol and 2 weeks after he got the Haldol. Think about the cold. I'm not, like I said, I'm not one way or the other. I'm not a mental health professional. But think about the cold. How do we apply the language and the date and the circumstances, the totality of the circumstances as we hear? Think about the bookends. His desire to confess was not correlated to either a change in his confinement conditions or the onset of psychosis. That's what the state says. Moreover, the record provides a reason why Alan began confessing in early April 2023 that has nothing to do with the conditions of confinement or their impact on his mental health. First, Alan experienced a markedly stressful event around the beginning of April. Okay, so I was thinking the stressful event that Walla described here was the confinement. No, the state says the stressful event was his legal discovery and meeting with his attorneys. That's interesting, isn't it? Was it seeing, and is the state going to say, seeing the result of the crime? Understanding the position that he was facing? Like what is all that about? Let's see what the state says. His behavior began to change and worsen immediately after these two events. Oh, here we go. The discovery materials forced Alan to face the horrifying evidence of what he did to AW and LG. Images and events he had been able to ignore and repress over the 5 years in which his guilt had gone undiscovered. He was also confronted by the realization that the state had sufficient evidence for a jury to convict him, and he was likely going to spend the rest of his life in prison. And he had to confront the realization that his family would be seeing these graphic images of what he had done. These realizations would be stressful regardless of whether one was already in pretrial detention, the conditions of that detention, or one's mental health, per the state. And we have a footnote here. Even if this court finds the confessions made during the period of psychosis between April 13th and May 1st to be involuntary, they were merely cumulative of the numerous admitted confessions made outside of that period. So they're saying, okay, look, even if they could be, and we're not saying they are, but even if they could be, these here, he still made these here, okay? Second, after spending time in Bible study, Alan said he found Jesus and accepted God into his heart on March 21st. He became preoccupied with religious matters and increasingly concerned about whether he would be reunited with his family in heaven and whether they would still love him if he had committed these crimes. Acknowledgement and repentance of sin is an important teaching in the Christian faith. A new convert's fresh concern with the status of his soul and the will of his God would lead a desire to confess his sins, particularly when the conversion happened in close proximity to the inescapable confrontation with the sin through the legal discovery. It is at least as plausible, like it could be this, if not more so, that the combined effect of his religious conversion and his receipt of discovery with its recommittant realities to be faced is what caused his confessions, not the conditions of his confinement or his mental health. So is it the religion? Is it the religion that did it? Because he went to Bible study. In addition to undermining any causal connection between the conditions of confinement and the confessions, the record also shows the state did not seek to exploit Allen's mental status to induce a confession. The purpose of his placement was not exploitative. Allen was validly transferred to DOC, Department of Corrections, as a safekeeper and placed in a restricted housing cell out of concern for his own safety, both from other inmates and from himself. This placement gave him significantly greater access to mental health professionals to help his pre-existing depression and anxiety problems than he would have had in the county jail. The state sought to offset the problems of social isolation by providing Allen with access to mental health professionals and a chaplain, regular exercise, regular contact with family, reading materials, movies, music, and an offered television. In addition to Allen's access to legal counsel, Dr. Walla advised him that he should not talk about his case with anyone other than his attorneys, and assured him that he did not have to talk about the case to receive mental health help from her. The state made no attempt to interrogate Allen after his mental health began declining. What date was that? When he became psychotic, the state did not ignore that condition while he continued to confess, but instead promptly initiated antipsychotic medication to restore Allen to his baseline mental health. Viewed as a sufficiency matter, there was that word, remember, sufficient, the involuntary sufficientness or whatever, the evidence supporting the trial court's ruling proves voluntariness beyond a reasonable doubt under the Indiana Constitution. So remember, they said the voluntariness had to be beyond a reasonable doubt, but it only had to be sufficient, which seems weird, doesn't it? I don't know. And here we have a footnote. Because he was a safekeeper, he was not subject to DOC's policy regarding placement length in restrictive housing. So we've heard that before, that there's only supposed to be a 30-day minimum or 30-day max on that. But he said, because he was a safekeeper, which is a different level apparently, there's no policy for safekeeping versus maybe a regular punishment. I'm not sure. And he had remained in the county jail. And had he remained in the county jail, remember I said usually they're in jail, not prison, two different types of confinement. And had he remained in the county jail, he would have still lived in a similar cell with constant video surveillance and minimal interaction with other inmates during comparable recreation time, but with no in-person visits with family or legal counsel. Okay. You see where we are. Okay. Allen's other state constitutional challenges are meritless. The admission of Allen's confessions did not violate the, quote, due course of law, end quote, provision in Article 1, Section 12. Criminal defendants do not have any general due process rights under Section 12. I believe they're talking about Indiana Constitution. The, quote, due course of law, end quote, provision, Section 12 applies only to civil cases. So the state's saying that there's no due process, due course of law, whatever that is, due process rights under Section 12. I don't remember if the defense alleged Section 12 specifically. Due process in criminal cases is protected only through the specific rights guaranteed by other provisions of Article 1. Thus, under the state constitution, the use of involuntary confessions is prohibited only through Section 14, privilege against self-incrimination. So I guess the states may be saying the defense is hanging their hat on the wrong constitutional item. Allen has waived his claim under Article 1, Section 15 because he raises it for the first time on appeal. In his motion to suppress and at the pretrial hearing, Allen alleged violations only under Section 12, 13, and 14 of the Indiana Constitution. He did not allege a violation under Section 15. At trial, he merely incorporated his arguments from the pretrial hearing. Constitutional claims raised for the first time on appeal are waived. We talked about that. And the appellate consideration in the first instance is particularly inappropriate when the constitutional claim is, quote, dependent on potentially disputed facts, end quote. Okay, so they're going through here saying it sounds like they're saying he's argued the wrong thing, and that Section 15 here applies to physical abuse, okay? Torture, beatings. Allen has not contended, either in the trial court or on appeal, that he was subjected to physical torture or beatings, maybe using those words, by correctional staff. His complaints about conditions of his confinement do not present a viable Section 15 claim. So they say here in this footnote, Allen erroneously cites Helton versus Miller for the proposition that Indiana Supreme Court has held that Section 15 applies to solitary confinement. First, the language Allen quotes on page 585 is not part of the opinion of the court. At 582, the quoted language is from the brief of Mr. Crawford, the attorney for the appellants, which follows the opinion in the reporter. So they're saying it's not the judge's discussion. It was things quoted by the attorney for the people that were appealing in that case. At that time, the court sometimes appended verbatim recitations of the parties' arguments to the ends of its opinions. So it sounds like they're saying the defense used the language from the attorney's brief and it wasn't part of the judge's opinion. So remember the judge's precedent when they discuss it, they use that language as the basis for the interpretation. So they're saying he used the attorney's language, not the judge's opinion. Second, the court's opinion does not even address or mention Article 1, Section 15, nor does the issue decided in the case have anything to do with the constitutionality of solitary confinement. So they're saying Helton talks about allowing convicts outside the prison walls to work. So they're saying basically you picked a bad case to hang your hat on. Harmless error. Now the state says even if all the confessions were involuntary, their admission into evidence is harmless. We didn't mean it. If it was, we didn't mean it. It didn't hurt the case. Okay? The erroneous admission of involuntary confession, and I'm smiling because I see another Arizona case here. Like we got Miranda, we got them all, right? The erroneous admission of an involuntary confession is subject to harmless error review. All right? In Arizona versus Fulminante, constitutional errors must be harmless beyond a reasonable doubt, meaning that they, quote, did not contribute to the verdict, end quote. And we've seen some portion of that previously, right? So harmless is harmless. It wouldn't have impacted the verdict in any way, shape, or form. Okay? So they're saying here, look, even if they were involuntary and they shouldn't have been used, he shouldn't have made them. If we took them away, they didn't contribute to the verdict, right? This is where they're going to go, okay? This is what they're going to say. The timeline, just like we went through the photo of bridge guy. Was it the photo bridge guy? No. Blair's bridge guy. The drawing. No, they said. It was Alan's confession himself. Okay. So now they're saying the timeline, eyewitness evidence, including Alan's initial statements to police alone, creates an overwhelming certainty that Alan was the bridge guy and thus the murderer. Okay, they're going back to that. Alan did this to himself when he said he was there. Alan admitted he parked near the Freedom Bridge entrance and began walking the trail at 1:30 p.m., which was corroborated by the surveillance video capturing a car, matching the appearance of his Focus driving towards the Freedom Bridge. He admitted he was likely wearing a dark Carhartt jacket with a hood, blue jeans, other tennis shoes or work boots, and had a hat with him, which matched the clothing worn by Bridge Guy. Alan identified himself as the man who walked past the Wilbur Voorhees group on the trail around 1:30. Doom, 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 doom. Wilbur and Voorhees both immediately recognized the picture of the bridge guy as the man who had walked past him. Alan also admitted that when he reached the high bridge, he walked out on the first platform and stayed there for a few minutes. Blair entered the trail at the Mears entrance, or just at 1:46 p.m., and when she reached the high bridge, she saw the man on the platform, who she immediately recognized as bridge guy. Neither Blair, Wilbur, or Voorhees saw anyone else on the trail. And Alan acknowledged seeing no one else who could have been bridge guy. So, there you go. As she walked back towards the entrance, Blair passed AW and LG on their way to the high bridge. And by 2:13, the man Blair, Wilbur, and Voorhees saw, the man Alan had effectively identified himself as being, according to the state, was following AW and LG across the high bridge and ordering them, quote, down the hill, end quote, while armed with a gun. That's it. He put himself there. By 2:32 p.m., LG's phone had stopped moving, and by 3:11 p.m., LG was not answering the phone when her father called, and she and AW had failed to meet him when he arrived to pick them up. Shortly before 4 p.m., Carbaugh saw a man she recognized as Bridge Guy walking westbound on CR 300 North, i.e., toward where Alan had admitted he had parked his car. His clothes were covered in mud and fresh blood spatter. Given Alan's admissions placing him on the trail and on the high bridge platform at the right times to be the man seen by Blair, Wilbur, and Voorhees, there's certainty that the man they saw in the Bridge Guy, the absence of anyone else on the trail who could have been Alan or Bridge Guy, and the tight timeline, this combined evidence created in connection to the abduction and murders, the only reasonable conclusion to be drawn was that Alan was the Bridge Guy, the person who murdered AW and LG, this per the state. But wait, there's more. Other evidence corroborated this conclusion. Most significantly, the unfired Winchester .40 caliber cartridge found by the girls' bodies was forensically matched as having been cycled through Alan's .40 caliber handgun. Alan had an identical unfired cartridge. Identical, they say. The only piece of Winchester ammunition found in his house in a keepsake box. Alan had no possible innocent explanation for how a cartridge that had been in his gun could have ended up at the murder scene. Bridge Guy had a gun and used it to compel AW and LG to go down the hill. An ISP trooper who had listened to over 700 of Alan's phone calls opined, his opinion, that it was Alan's voice heard on the video saying, quote, down the hill, end quote. Although Alan had 12 cell phones in his bedroom closet, he did not have the cell phone he had told police he had with him on the trail, creating a reasonable inference that he destroyed the phone because he knew it contained evidence of his guilt. Alan also displayed consciousness of guilt by lying to police. Although he originally told police he was at the trail from 1:30 to 3:30 p.m., parentheses, and the testimony of Wilbur and Voorhees proves he was arriving at the trail, not leaving it at 1:30 p.m., in parentheses. When the police re-interviewed him in October 2022, Alan claimed he was at the trail much earlier, from 12 p.m. to 1 to 1:30 p.m., showing he understood the damning implication of the initial timeline he had admitted. While police executed the search warrant at his house, Alan said multiple times, quote, it's over, end quote. In the face of this powerful evidence of guilt, the jury did not need to rely on the confessions at all to return its verdicts. Okay, we're not done. We're not done. We're going to continue. Let me know if you have comments below, what you think, and we'll keep going. Thanks for being here. I would love it if you would like, subscribe, and share. helps me get the word out, helps me do more for so many, helping identify our unknown humans, helping solve cases that sit unresolved. And like I said, just do more. I appreciate you being here. I appreciate you listening to me. And I love hearing what you have to say. I'll see you on the next one.